Who owns AI-generated content? Imagine creating a piece of art, a song, or a story with the help of artificial intelligence. Who really owns that work? That's the big question many are asking today. As technology advances, laws are catching up, but the answers aren't always clear. Let's break down what we know so far about who owns content made by artificial intelligence. Artificial intelligence-generated content includes anything from images and music to text and videos created by AI systems. These systems often respond to prompts or instructions from humans, but the actual output is produced by the machine. Unlike traditional art or writing, where a person is the author, AI works challenge existing rules because they are not human creators. In the United States, copyright law is quite strict. It states that only works created by humans can be protected by copyright. Courts and the Copyright Office have made it clear that if an AI makes something entirely on its own, without meaningful human input, it cannot be copyrighted. So, if an AI paints a picture or writes a song without human help, no one can claim copyright over that work. The reason is that copyright is meant to reward human creativity, not machine output. Some states are starting to create their own rules. For example, Arkansas has passed a law saying that the person who gives the instructions or prompts to the AI owns the resulting content. But there's an important exception. If an employee uses AI as part of their job, the employer usually owns the work. Still, these state laws don't change the federal copyright rules, which remains the main authority. Other countries are also working on laws about AI content. Some are thinking about giving limited rights to AI-created works, while others follow the U.S. approach. Since laws differ around the world, it can get complicated for creators and companies working across borders. When humans are involved in the process, like choosing, editing, or shaping AI output, the work might qualify for copyright. If a person makes significant creative choices, they could own the final piece. The Copyright Office says each case will be looked at individually to decide if the human contribution is enough for copyright protection. Another big issue is how AI systems are trained. Many AI models learn from huge amounts of data, including copyrighted books, images, and music. Whether using this data is legal depends on fair use, a doctrine that allows limited use of copyrighted works for things like education or research. Courts are still deciding how fair use applies in AI training, which could influence future ownership rules. For creators and businesses, these laws matter a lot. If you use AI to generate content for marketing, art, or music, you might control how you use it, but others might copy or reuse it if it's not protected by copyright. If you make major changes or combine AI work with your own ideas, you might claim copyright in the final product. But it depends on how much human input there is. Employers should also be clear about who owns AI-generated work made by employees. Some state laws offer guidance, but federal rules still hold the main authority. Looking ahead, the legal scene around AI content is still changing. Lawmakers, courts, and regulators are working to find the right balance between encouraging innovation and protecting creators' rights. For now, the main point is that in the United States, works created solely by AI cannot be copyrighted. Human involvement is key to claiming ownership. As AI technology keeps evolving, laws will continue to adapt, but staying informed is the best way to navigate this new world of digital content rights.